Bonjour à tout le monde. On va commencer cette session, ce webinaire sur Secondment and Expatriation to France, pardon. Aujourd'hui, nous avons le plaisir d'accueillir la société d'avocats Coblence ainsi que Cam Immigration. Alors, pour Coblence, nous avons Myrtille et Alexandra Briens. Et puis, pour Cam Immigration, nous avons Fiona Mougenot. Donc, ce que je propose, c'est que vous commencez tout de suite votre présentation.
So nice to meet you, everybody. We'll switch to English to enroll you all on this presentation. So our objective today is to present you the key aspects in relation with secondment and expatriation to France. So the main topics we will cover are basically labor law, social security law, and immigration law. So what I will do then, because we have a sound issue, I will start presenting it, and when the slides are available, I will show them to you. So the first thing in relation with labor law aspect is to make a distinction and understand the distinction between secondment and expatriation. So secondment is also called posting of employees. So regarding labor law, there is no definition in the French Labour Code on secondment. Basically, secondment posting covers a temporary assignment in France, and the subordination link is maintained with the employer, okay? Whereas expatriation, which we also call local status, there is also no definition in the Labour Code, but here there is no subordination link maintained with the initial employer or a very weak connection. So basically, in this situation, you will have usually a local French employment contract, okay? So this is the two main distinctions, and they are more clear regarding social security law, but Myrtille will comment on that later on. When we are talking about secondment and posting, and will be the key part of my presentation, there are various obligations that apply to you as an employer. So just to list them to start with, the first obligation is what we call a pre-settlement declaration. You need to make a declaration regarding the employees you second in France, and you do that on a specific website called 60 website, and I will detail that in a few minutes. You also need to appoint a representative in France who will basically be the contact point if there is any question, for instance, from the labor administration. And also, you need, regarding your seconded employee, to comply with part of the French employment law. You need to store several information, again, if the labor inspector, the labor administration asks you certain information regarding your seconded employees. And you have also additional obligation in really specific sector, such as if you are in the construction and public sector, or if you are a temporary agent. So we will not focus on those two last ones, which are really specific, but we will detail more the other obligation. So your first obligation, I just mentioned, is about making a declaration of secondment. So you do that on an electronic portal. The good thing for you is that this portal is in English, okay? So this will be very helpful for you. So when do you need to do that? Basically, you need to do that just before posting an employee in France. There are, however, good for you also, a few exceptions, not a lot, but a few ones. First, you don't need to do such declaration when you post an employee on your own account, meaning that you don't second your employee to a company of the group or to a client, okay? In this kind of situation, you don't need such a declaration. So for instance, you ask a UK employee to come in France to go to a seminar or conference, you don't need to do a posting declaration, okay? Or you just ask him to do a commercial visit, okay, to a prospect, then you don't need to do a secondment declaration. Another exception is for really specific types of activities, mainly related to punctual events, where you don't need to do this declaration. For example, an employee attend to a seminar, or for artists, for example, an actor, okay, you come in France, you don't need to do the secondment declaration if it's an employee. If the secondment isn't more than 90 days over 12 consecutive months. Also for sportsmen, you don't need this secondment declaration. So this is really will be useful for LPGAs, for example, because as you may know, in 2024, Paris will be the place where it will take place the Olympic Games. Then on this CIPSI website, you will see that you have various information to provide. So basically, you give information on the employer, information on the company who is receiving the employee, information on working time. So I actually went on the website this morning, so I can tell you exactly now once that all the information is asked. You are asked to give the working hours, to start hour and hour. So you need to be careful with that because rules regarding working time are specific. Okay, and this declaration you make is sent to the Labour Inspectorate. So if the Labour Inspectorate sees that you will have your employee work 50 hours, you will have a little problem because, as I will talk later, then you will need to ask a derogation to the Labour Administration to have your employees work 50 hours. So you need to be careful when you complete, this declaration, because someone might read it and might ask you a few things to clarification. You also need to give information on accommodation, how you will compensate for professional expenses. You also need to indicate to what social security regime the employee will be subject to. And also on this document, you need to appoint a representative. I will talk in more details in a few minutes about this representative, but basically it's a person who is there in France, or not necessarily in France, but as a contact point for the Labour Administration. So if he has an issue, for example, on working time, he will send and contact this representative. So as I say, you do this declaration online, and it is received by the competent Labour Inspectorate, so usually the Labour Inspectorate of the place of work in France. It's quite important to do this declaration because if you don't, there is a fine of 4,000 euros per posted worker, which can be 8,000 euros in case of reoccurrence of the offence. But be reassured, it cannot be more in total than 5,000 euros. A copy of this declaration must be given to your clients, so basically to the person, the company that benefit from this posted employee. In practice, on the CIPSI website, you need to give the contact detail of the company who benefit from this work. So usually it will be automatically sent via the CIPSI website to this company. It's important to do that because if you don't, normally the company has an obligation to report you to the Labour Inspectorate, because otherwise, for example, you fail to pay the salary to your employee, you don't pay your social contribution, the company who benefit from the work will be held also liable with you if they didn't tell to the Labour Inspectorate that you didn't comply with your obligation. So it's really nice. They need to denounce you, but it's good that you know about this specific obligation. If now I talk about the second point you see on the screen, which is about appointing a representative. Also, just be reassured, after the presentation, we will send you the slides and even the version a bit more detailed than the one you see. So you will have all the details I'm mentioning on the CIPSI website, representative on the slides. So just in case you are taking notes, you know that you will have a detailed presentation after the meeting. So regarding this representative, as I just said, you need to appoint this representative at the time of making the CIPSI declaration. You don't need to appoint a representative in case you are exempted from making a CIPSI declaration. So just as I mentioned, for instance, if you second an employee on your own account. Again, if you forget to appoint the representative, you incur the same fines as in case you forget to do the CIPSI declaration. Why do you appoint a representative? As I mentioned, this person will be the contact point for the administration, tax authorities, labor authorities. So if they have any question, they will come to that person. On the CIPSI website, you will need to give the name of the person, you will need to give his contact details. This person can be a physical person, it could be also a company, or even the employee second in France, okay? Because sometimes you only second one employee, it might be easier just to have this same employee being also the contact points of the administration. On the CIPSI website, you will also need to indicate where various documents are kept in case the Labour administration asks to see those documents. I will detail those documents in a few minutes. So another aspect regarding secondment, as I mentioned, is that you need to store several documents in case the administration asks for those documents. So you will see in the detailed slide, we will send all the various types of documents. I will perhaps not enter in too much details here, but basically those documents are here to ensure that the employee has an employment contract. The administration wants to have some information on working time. So you will need to monitor the working time of your employee seconded in France. They need also to see payslips and so on. So they want documents to ensure that you comply, with your obligation as an employer. The tricky thing is that those documents should be provided in French and with no delay to the Labour Inspectorate if he asks to see those documents. So in practice, it's not always that easy because let's imagine all the cost of translating an 100 employment contract because you second 100 employees for Olympic Games, for example, in France. So let's hope that the Labour administration, in particular for such type of events, will be a bit more tolerant because, to be honest, our clients never or rarely translate all the documents which are required, by the administration. In some, again, specific situation, the law says that you have 15 days after the request to provide those documents, but this exemption is quite limited. For example, it concerns when you second an employee on your own account, and only regarding documents in relation with the occupational medical visits, which is one of the obligations you have when you second an employee, and you will see that on the details slide we will send to you. So the first set of documents are really documents related to the employee and the employment relationship. Then you need to have another type of documents which are more related to the business. The idea is to provide certain documents or make those documents available, showing that you have a real business in your country of origin, because otherwise, if in reality you have a business in France, it's not anymore secondment, and then you have also tax implications because you might have to pay tax, in France. So it's why you need to be able to prove to your administration that you have an activity in your local country, your country of origin. So, for example, you will be asked to provide a document showing how important your business is and how many commercial contracts you have in your country of origin. Again, those documents should be provided in French, not really practical, and normally with no delay, but with some exceptions. Again, if you second employees on your own account, you will have 15 days to provide those documents in relation with your activity. So you will see all the detailed documents required on the more detailed slide we will provide you after our presentation. Then when we talk about secondments, then obviously the employee will come and work in France. So you will need to comply with French employment law. Not all French employment law and the law to which you need to comply depends on how long you will second your employee in France. So the first scenario is the one when you post an employee for a period up to 12 months. Then you need to apply what we call the core provision of French employment law. So it's not all employment law, but quite a big part of employment law. So for instance, you need to comply with non-discrimination. You need to comply with the right to strike, the right to strike in France. You need, as I mentioned, to comply also with working time. So again, this is quite important because it happened that we help our clients to ask the Labour Inspectorate Commission to derogate to working time. Just as you know, normally employees mustn't work more than 48 hours a week in France and no more than 10 hours a day. So if they will work more, it should just ring a bell to you that you might need to apply for a derogation or check also the collective bargaining agreement, which sometimes allows you to derogate to working time without asking permission of the Labour Inspectorate.
You can explain the case.
what was the situation you were facing in specific again?
Well, I've been in various situations, such as clients organizing or coming to film an event, in France and having the need for their team to work on Sunday or long hours just to film, this events. Also, I had to work, for example, on a company who was coming to, how to say that in English? Mining work in France, okay? And which was quite technical work, so they had to work like for 3 months, day and night with teams changing all the time, but they had to have a permanent continuity on the place because otherwise it could be a security issue. So then we applied for a derogation for the labor inspectorate. And for example, we asked the employees to work like more than 50 hours, like 52 hours. And we say, please, could you reduce to 50? So we managed to hire one or a few people more to satisfy the labor inspector. But this is the kind of situation where we can assist on such topic. Then, if your employee is seconded for longer than 12 months, then you apply more provision of the French employment law, such as provision regarding training, provision regarding institution of the employment contract. However, there are a few exceptions. You will not apply, for example, the rules regarding termination of the employment contract. So termination of the employment contract will still be regulated by the law of the country of origin. So that you are fully aware, it is possible for you to ask an extension, meaning that I just said that for 12 months you apply the core provision of French employment law, and after you apply more detailed provision. So you can ask the administration on the CIC website to extend those 12 months to 18 months, but you need to make a request on the CIC website and to justify it. Be also aware that the law has also introduced provision to avoid fraud. So if, for example, you have seconded an employee for 12 months and you decide just to change the employee for another 12 months period, saying, great, I will only have to apply the core provision. No, because the administration will look at the fact it's the same job. So even if you change the guy, okay, you still have done the 12 months, so then you have to apply all the provision of the French employment law. So you can not only change, the employee.
Can I just ask you one question while you're on that? What about if there's a rotation, but was a cut-off? If it was 3 months or 6 months, are we still going to be in the core, or we're going to be in all the main?
Well, they're looking at the period they have been reached 12 months. So I assume that if you have a cut-off, that would be okay, but it should still be like a real cut-off, you see what I mean? Just like not 1 week or 2 weeks. So I think it should be okay. I would, to be honest, I will double check how exactly the legal provision are written.
I'm not sure you have it.
Yeah, exactly. It's again always a question of is it a fraud? You see what I mean? Or not? But probably if you have a clear break, then they will assume that there was it's not a continuous work. You see what I mean? So it's not basically a fraud to your obligation. So this has been, quite a lot of details, but regulation regarding secondment of employees is quite technical, and you have several steps, to comply with. So you can go through our presentation later to have all this written. So this was the situation in relation with secondment of employees. So as you remember, when you keep your contract of origin, when the employee keeps his subordination link with his employer of origin. Then there's another situation, which is expatriation of an employee in France. So this time, basically, there is no more usually subordination link. So either you suspend the original employment contract and then you sign a local contract in France. Another option is that you terminate the contract of origin and you have a local contract. But expatriation is really more a concept which has to do with social security law, and we will talk about that in a few seconds. Also, but perhaps Fiona, you want to comment on this one, in relation with intra-group transfer,
should the employee be posted to work on a client site in France, it is mandatory that the category is expatriation, so that you have a local French employment contract. And this is linked to the requirements about talent passport employee.
Yes, one of the risks that for intra-group transfers that people need to be aware of is that you can't do double posting or double detachment of an employee. You can't post them to your subsidiary in France and then say, I'm going to send them to work on site for client B in France. That is not authorized. You're going to be on a double detachment. Therefore, if you're going to use the intra-group transfers, which are the easiest to be used, and providing, of course, one meets the criteria, the employee there would have to be on a local French employment contract. Therefore, it will be the talent passport employee on assignment.
Thank you, Fiona. So this was basically an overview about the obligation in relation really to employment law. So now we'll let Myrtille discuss and present a little bit the rules in relation with social security law. Thank you, Alexandra. So in my view, and we just discussed that, this one is maybe the easiest one. We'll mainly deal with the EU regulation in this quite detail. From my experience, in the case we're facing, I would say that issue raised more or about employment law, so the way it will be applicable. They will have SIPC, they will have SIPC, then issue will be around working time, and honestly, most of the time it's about immigration. So about providing the rights, but mainly for social security, the client will have the A1. So what is the concept around social security law? So basically, it's where you are paying your social contribution. The principle is to avoid to pay your social contribution in several states. So we'll have a general principle where you will pay your contribution, social contribution, where you work as an employee. So that's the basics. And then you have two concepts, which is secondment, which is basically you will pay your social contribution in your country of origin, where in the case of expatriation, it's a bit strange to me, where here we are expatriating in France, where I'm used to talk about expatriation outside France. Here in this case, you will have to pay French social contribution in France. That's the main difference. So the first question that you will have to answer is, do I have any legal grounds to avoid paying social contribution in both the country where your employer is and in the country where the employee is working? So first case, no convention, no agreement between the country. And in this case, where your employee is coming from abroad in France, you will have to pay the social contribution in France, and probably you will have also to pay your contribution in your country of origin. In most of the case, you have a convention between the two countries. For example, between the US and France. And in this case, if the conditions are met, you will have the possibility to maintain the payment of the social security in the country of employment. Again, the general principle, avoiding double payment, but also for the employee, some kind of continuity. So avoiding that an employee that will work around the world will have one-time contribution in France, in the US, in the UK, so they can maintain their global regime in the same country. Duration varies depending on the convention. Most of the time is up to 5 years. Again, it's the case for US French convention. And you will have a certificate form from the Social Security of the country of origin that would allow you to go to doctors or to deal with your day-to-day needs in France. Maybe the most important, even if it's at the end of the slide, is what happened with Brexit. Globally, in my opinion, we can discuss that. So the EU regulation about secondment, or how to organize, because you could also have multiple employers. We can work for example, in two countries at the same time. The EU regulation are quite detailed. So it's providing with a lot of clear rules about how you, where you should pay your contribution. So one of the questions was about what happened after Brexit. So you have the trade and preparation agreement. It basically we'll go into detail what is the EU regulation. It's very, very similar. Secondment is linked to limited period of time. So it's question of time. The rules is now that secondment is 24 months. It used to be 12 plus 12. The main exception in the trade and cooperation agreement is that the secondment is limited strictly to 24 months, where we would see that in the EU regulation, there is some possible of extension. So basically, the rules that we would explain after would also apply to for UK when it was requesting an employee from the UK.
Doesn't want to change. Why?
Okay, that's okay. So
promise I did nothing. Probably, to be honest, it's never near the computer.
So yes, secondment is in the EU regulation, and basically, even if we think that could be up to five years with some country, in the EU it's 24 months, and you will need to obtain the famous A1 form that used to be the E101, which is the form that the employee will have to provide. So what are the conditions to be in the secondment umbrella? Regarding the employer, so the employer normally carried out its activity in a significant way in the member state where it is established. So it should, and for almost the notion that we would see, there is a specific regulation that provides details of what we should understand by significant activity. So all definition is most of the time, the regulation will provide you with details. Maybe most important, and is because it's also linked to employment law, is a link of subordination. So you will have a link of subordination between the original employer and the employee during all the assignments. So the employee is seconded for an activity carried out on behalf of the original employer, and the employee must not be sent to replace an employee which is seconded for the same assignment. Then you have a condition regarding the employee. The employee may have been recruited with the view to being seconded and maintained under his usual security scheme if prior to his recruitment he has been subject for at least 1 month to the legislation. So the question
and then it is sometimes a question we have is, do you have to have an employee that was already working for you, or can you hire an employee in the view to second the employee? So here we have a clear answer. It is just at least 1 month, and we will see with Fiona that sometimes it's not working for immigration. I'm just saying this because we have a case with friend about length of services in the original country. So if the conditions are met, you will be under the secondment. If they are not met, most of the case, for a question of time, it is the case that we are facing most of the time, you will have to pay the French social contribution. About the extension, possible of extension, most of the case, if you have strong reasons, so I would say typically because you are an assignment for doing some, mining, for example, and the mission is taking more time than you were expecting, you will explain why you need the employee to stay in France, and you will obtain the extension. So you will need to clearly explain the reason, but if you have a fairly reasonable grounds, you will obtain the extension. So before, because I think that's before allowing Fiona to speak, maybe one thing that we are facing more and more is remote work. So how we should decide to pay, where we should pay the contribution, where you have an employee that is supposed to work for a French company from outside. And I will be very happy to share with you around that. In my opinion, no clear answer. We had a discussion with the CLES not a long time ago, which is the organization that is coordinating the bio-social security regime. We had a very old case law, 20 years maybe, around officer, where the officer was working from abroad, but the decision considered that he has to pay the contribution in France because the work was for the French market. He was coming sometime to France, and he was sending emails in France.
And basically, he was managing the French
company. He was managing the French company from abroad, which was a case that we have to face very recently for a manager, from the CEO of the company that was working in Canada for a French company. And so based on this case law, first reaction was working from Canada, but for French market, so he has to pay in French, but which is not in practice, which is a nightmare because he's living on a daily basis in Canada. And when we discuss this with the class, they say, no, obviously, he has to pay the social contribution in Canada. So we are supposed to do a rescrit, so to ask the French administration, but we do not have the answer yet. But clearly, it would be more and more.
And it's logical because let's imagine he has the French social security, he's ill, but he's going to see a doctor in Canada. Not really easy to have his reimbursement. So there's also a logic. So let's hope they will confirm
they will be
what they told us. Because the rescrit is a way for you to ask questions and have a written confirmation from the administration if you are in doubt of something, so that then they can't, ask you back pay of social contribution because you ask the question and you obtain the answer. So it can be useful in case you have a.
But clearly, the last few months, I would say that this question was the most often question asked by our clients. and we are trying to be as practical as possible. I think it's also a question for that you will deal with.
Yeah. And before just switching to Fiona, I forgot to talk to you about the recent statistic that has been given by the administration, the DARES, in October 2021. I found it quite interesting that perhaps because of COVID, but also because we changed the way of working, there has been a drop in the number of employees seconded in France. So if we compare 2021 and 2019, it's less than 21% less of people who are seconded in France. Mainly, it's quite interesting. It's mainly in construction work that people come in France. It's mainly men. So they went really in detail, statistics. So on average, that there are on average 57,000 employees seconded every day in France. 57,000 employees seconded. I found it quite interesting to see the level, how many people are in this scenario, because make it more concrete.
Make a lot of things. 21.
I'm sorry.
This was in 21.
Yes, the statistics were just given in October now, just this October. The DARES published this communication. So, 57 500 en moyenne par jour.
Per day.
Per day.
Per day.
It's 57,000 on average per day. So on a given day, on average, you have around 57,000 people seconded in France.
And I think that's mainly in construction.
Yeah, because in the statistics, it's quite detailed. It's mainly in construction.
And that takes into account EU and non-EU.
Yeah, exactly.
And short and long.
Everything.
Yeah, exactly. But I found it interesting because you see how many people we are talking about here. And it's quite a few because.
And so one of the things that we've seen in the last few months is also the use of umbrella company. And I have nothing against umbrella company. I start my work by the fact in France, portage, so umbrella company was strictly forbidden. So the things are moving, but clearly the last issue we had to deal with was because the employee was employed through an umbrella company. So SIPSI was okay, A1 was okay, and the other document was not okay. So because they are moving employee in all the words, and they are considering that they know all the regulation, which is not true. And we clearly have more and more cases around umbrella company and our client using umbrella company.
But to agree that umbrella companies employ foreign nationals, so they become, in a way, expatriates. They're not seconded employees.
It depends.
So he's not involved. Right?
It depends.
It's a French portage contract.
The thing is, in different country, umbrella company have not the same definition. So and we have a lot. We used to work in a UK law firm, so we have a lot of clients that was what we would have considered as an umbrella company in France, so very strictly regulated, but was in between headhunter and umbrella company. So they are just, providing employee to the client. Yeah, exactly.
Yeah, reality.
Exactly.
And this is the risk because you can't do like that. For example, it was an American firm who wanted to hire a salesperson in France, okay? So he didn't want to do the contract and so on. So he used our client, but our client hadn't really declared his activity as portage, okay? Oh. So the guy was working for this company, so our client, but all the work, everything was given by the client, you see what I mean? So the target, sales target, even shares, free shares were given to this guy who was not the employee. And then they decided to terminate the notice, but it's not our client who sent the letter. It's the beneficiary of the work who had the brilliant idea of telling to this guy who was not the employee that they would end his notice. So then we have to negotiate a nice settlement agreement, okay? Basically, it's proved that the real employer was not the one who signed the employment contract, which is
which is an issue. But it's interesting because it's now, I mean, it's the reality of the modern world. You know what I mean? We need to change our concept and so on, but obviously the law is slower than the imagination of all the companies.
and we have also issue around compensation with this type of, we did not deal at all with compensation, with also, of course, obviously, clearly a discussion around package and we have another example where it's an umbrella company, but the final client is willing to grant the similar benefits with his own employee in the US. So he's granting, for example, a very specific token, but he's directly granting the benefits to employee, which are by definition employee of the umbrella company. So there is some kind of confusion at the end of the day. So it is really something that we have maybe on a daily basis currently. So I just wanted to.
So you see, we are very enthusiastic on all that topics, but I think we need to give some time to share. Sorry. Also really interesting.
I'm going to jump in directly. I'm literally going to skim over most of this. I think that everybody's had a lot of information, and you're now going to see the real complication of information. And we haven't even talked about tax, thank goodness, because then you will really wonder. So I'm going to start off with a very, very short story, just to sort of set the pace. I have a client, Sea Air, and the CEO, Brian Smith, gave me a call. They have a French client, Albatross, here in France, and Sea Air, as their name says, they're in sea wind farms, okay? And there are a lot being set up here in France. Now, Sea Air have 6 employees, they're engineers, they're British nationals, all of them, and they've been coming to France, and Brian says to me they've spent about 59 days here. They haven't done anything. They've just assumed we can just pop in, do some work, pop back. But Albatross had a labour inspection. And so he gives me a call and he says, but Fiona, what am I meant to be doing? And this is all thanks to the chamber, because the chamber put me in contact, and Brian can thank you, Catherine. And so he says, but what are we meant to do? So I said, well, first of all, you're going to have to do SIPSI declarations, and then we're going to start looking at the rest. So let's jump in straight away. So the first question is going to be, this is an absolute basic, is it short-term or long-term assignments? Short-term, we go to the Schengen ruling, 90 days during a 180-day period, which is rolling. So it's complicated. In the slides that we'll be sharing, you have a link to a very good calculator, and it's just like tax. If you have assignees, you should do that. And that includes not just traveling to France, but to any of the other Schengen countries. So you have to be super careful on calculating that, because otherwise your employee can be overstaying. And long-term is anything above that. So let's move into the next slide. And I'm going to start off briefly with the intra-company transfers. If you have an entity here in France, this is going to be the easiest process that you can do. And you have 2 categories. You have secondment, or what immigration people who are here would call detachment. So I'm going to be talking about detachment, but it's secondment, posted workers. And you have a local status as well. Generally, the local is used for long-term as such, and the posted is used for short-term a lot of the time, or longer-term if it's going to be, like, let's say, for 12 months or 18 months. So you don't want to move them onto the French employment contract. So the basics on an intra-company transfer, the posted worker, is that your employee has to have 6 months employment within the group prior to filing for the application. Gross salary, here we go. Gross salary has to meet the French company's collective bargaining agreement for the same position and the number of years of experience, of course. The posted worker should be for a senior management position or to provide expertise. Now, that is very, very grey, and We won't go into the details. Most lawyers were going to be able to find a solution around that. But it's certainly not, shouldn't be for a junior as such. And one has to look at training as well. The maximum duration, now this is where there's going to get complications, is 3 years. Now this is general for all secondments, okay, on immigration. But then you have to start thinking about what Myrtille says, but what's going to happen on the social security front? So if on the social security front you did have a British national, you could say, okay, the first 2 years he's going to be on secondment from a social security perspective, remaining on the UK social security, but the last year he's going to have to be moved onto French social security. So this is where it gets super complicated for people who don't know too much about global mobility, is that Myrtille is going to be saying, oh yes, but he's local social security. And I'm going to be saying, yes, but from an immigration, he's actually on detachment. So that is number one of the things that gets complicated. Very, very important, the line of subordination. We can't stress this enough. You should keep documents that clearly show the line of subordination remains in the home country. Timesheets, I always say, should be signed by the employee and the home country manager. And it's one of the things that is needed for the legal representative here in France. Remember, cannot be posted to a client site if it's an intra-company transfer on detachment. So there are advantages and disadvantages. The advantages mainly are that it's a 2 to 4 week process. The employee applies directly at the consulate. There's no extension on that. The family, though, will get, or the spouse, and I'm talking about a spouse, you have to provide a marriage certificate here, so it's not partners. That would fall into another one of our friends who are here. Spouses would get work permits automatically, or would get a permit that allows them to work, open a company, have any activity that they want. Disadvantages is always the same thing about not working on a client site, no extension after 3 years, and no filing of anything else. One of the big advantages for the company is that the employee cannot change employers. So they're not going to walk away from you. Expatriation, a little bit different, is that it's a 3-month employment prior to the group, but here there's a minimum salary, and that is the absolute strict minimum, but you do need to check on the collective bargaining agreement. If it's higher, you have to take that one. Employment contract, which Myrtille and Alexandra have explained, it's local. Permit here will be for 4 years, can be extended, and can work on a client site. So that's pretty good. The next one is about the advantages, which are pretty much the same. There we go, as the others. The only disadvantage here, the main one, is that it's very difficult to obtain a 10-year permit or French nationality. One can try, but most of the time it gets refused. So people will come back and say, oh, Fiona said absolute nonsense. I've filed so many and they've all got through. Fine. But if you look at the statistics, it's not too positive on that front as such. So what about posted workers, detachment, who are not on an intragroup transfer? Now, these are the ones where you have to be super, super careful because the liability here is, so the liability in France is always with the company where the employee is working as such. So that means that if you're posting an employee to France, you have to remember that your client is going to be equally as liable as you are. And probably their legal team is not going to play in favor of you, but in their favor. So everybody's going to be passing hot cakes around saying, oh, I shouldn't have done it, you should have done it, and I didn't do it, etc. So you have to
Let's call Fiona.
Not Fiona.
Yeah.
For the trial.
So this is exactly what happened to Sia, my client, or my hypothetical client, and Albatross. Because Albatross, of course, got extremely worried with the labour inspection and started saying, but you haven't done anything, but they know that they're liable as well. So you have to put in place a lot of red flags. There must be a service agreement. And the service agreement is with the entity that employs the employee. And that can also be an issue. Now, Either you can add in addendums. You should always speak to the attorneys about this. You could add in an addendum into your employment, into your service agreement. Tripartite are very rarely accepted by the labour inspection, but you could have a good lawyer who could defend you. But that, I'm just saying that they don't like seeing that, and they don't most of the time like that when you apply for a work permit either. So you have to be careful about that. You have to be very careful also about the fact, because we're talking about employees here, but a lot of the UK companies and a lot of other companies forget that some of these people are not employees, they are freelance contractors. And that is also another big issue, especially around the service agreement. So depending on the individual, the employee here remains on home country employment contract. If in the UK, let's say to begin with, at least for the first 2 years, he's going to be on his UK. And if he's an independent worker, he's going to be billing his services. Now that is going to be decided, who is he billing? But he should be billing the client in France, but most of the time he won't be billing the client in France. So we're getting into a lot of red flags here. There is a minimum revenue salary, which is the minimum French requirement. But again, you've got to look at the collective bargaining agreement, and you're always going to have to look at it. So some companies may be working on construction. They may have unskilled labor. Well, they're going to have to go to that, which let's talk about companies that are coming from Eastern Europe. Obviously, the salaries are much, much lower. They have to give this salary plus everything that Myrtille and Alexandra spoke about. Maximum duration, absolute maximum duration is 3 years. Most of the time, you shouldn't go to 3 years. Let's say it's 1 to 2 years. That's my personal opinion as such. And line of subordination always remains abroad. So the advantage is that the employee, we're talking about an employee, he cannot change employers. He cannot work on another project. It's absolutely his work authorization is going to just be for that. If we're talking about long term, where a work permit is going to be required, it's 6 to 10 weeks. So that's long. And then you've got a visa. So this really has to be planned. Okay? Now, as we're running out of time, I'm going to go straight forward into short-term exemptions, which is the next slide. So France has created a wonderful little category, which you also have to be extremely careful about. And yes, there is a category for short-term assignments, which is work permit exemption. So here you have the categories. It's IT, management, finance, and insurance, architecture, and engineering. So it covers a lot, but you have to be very sure that the employer says that this person is an expert. So don't send a junior using this. That's not going to work. But yes, somebody who's an engineer who's got a couple of years experience, I always say a minimum of 5, because I'm a little bit cautious about it. For a short term, could be work permit exempted, but the SIPC filing still has to be done and a legal representative has to be designated. All the other rulings are going to apply. Yeah. And we also have the problem about distance workers, teleworkers. I think that probably, or I hope that probably France is going to come up with a visa like other countries. President Macron wants France to be the Silicon Valley. So I think that this is something which a lot of us would like to see lobbying, because today what you see under there is a reply from French consulate in Washington that a teleworker or distance worker who is working from home, not for a French company, not for the benefit of anything in France, client, project, etc., can apply for a long stay visitor's visa and does not need a work authorization. But if you go to the lawyers, they're not going to be very happy about that because it's getting into a lot of risks as such. But modern era, yes, this exists as such. So we have a couple of red flags, and then we're going to be able to see if anybody has some questions. Short term, always the big thing is do not use a business visitor status. Work is not authorized. What is authorized under a business visitor status? Commercial visits, conferences, company group meetings that are not for the benefit of the French company.
Subtle.
Very subtle. And anything else could require a work permit or a CIPSI declaration or something, but it should be viewed exactly what an employee is doing here in France. You also have to assess whether the work performed is for the benefit of the employing company or the client in France. Also something which is very subtle, the calculation of the days spent. This is something which we're running into the whole time. Catherine sees it the whole time. I have calls every week. UK companies, what am I going to do? They've reached 75 days. Well, there's not very much you're going to be able to do. People are playing around with second passports. You have to be very careful. Our second passports has the advantage of being able to apply for visas, but you are in a system, and if physically you have spent the 75 days, it's not because you have a second passport that you could spend other days. That's not authorized. But okay, people will take the risk and say, nobody's stopping me right now. And if you want to be compliant, please ensure that 100% is there, which is difficult, very difficult. But that is one of the things. And posted declarations apply to all employees, regardless of nationality. I have French employees who are posted from Singapore to France. CIPSI declaration. It's mandatory. It's not your nationality. It's where you're employed from that you're posted to France. And last little point, you can also verify if your employee is married to a French national or an EU national, because if they are, and if they're coming to France, so the spouse has to be, the French or the EU spouse has to be coming to France, then a French national automatically should be applying, if it's long stay, for a long stay visa, a spouse of a French national. It is mandatory. And if the authorities found out that you apply for something else, unless they have agreed specifically because this point has been viewed, they will say no, they should be applying for the French, spouse of a French national. And spouses of EU nationals have the benefit also of being authorized to work in France. They would not require a visa, they apply directly in France. So that is all for immigration. It was quite quick, but it's to explain that we all have to work together. And I always say to any of my clients, the first step is to be speaking to lawyers, especially around employment law, social security, and around tax, which is a huge, huge subject and equally as complicated. Basically, immigration after that, a lot of the time, except for the counting of the days, but a lot of the time we fit in.